Welcome to the appendix, where we read the primary sources of the past so that the present can be better understood. Today's primary source, the Intolerable Acts, 1774. The Boston Tea Party of December 16th, 1773, and the disturbances in Boston and Massachusetts led Lord North to ask Parliament to vote a series of measures adequate to the emergency. March 14th, the first of these notorious intolerable acts was laid before Parliament, the Boston Port Act. The introduction of these measures led to one of the most notable debates in parliamentary history. Ultimately, 5 coercive acts received the royal signature: the Boston Port Act, the Massachusetts Government Act, the Administration of Justice Act, the Quartering Act, and the Quebec Act. The provisions of the Quartering Act, provided June 2, 1774, are essentially similar to those of the Quartering Act of 1765. 1. The Boston Port Act, March 31st, 1774. The Boston Port Act, the first and most odious of the intolerable acts, was designed specifically as a punishment of Boston for the lawlessness of the Tea Party. The reopening of the port was made conditional upon the payment of damages for losses sustained by the East India Company. An act to discontinue in such manner and for such time as are therein mentioned the landing and discharging, landing or shipping of goods, wares, or merchandise at the town and within the harbor of Boston in the province of Massachusetts Bay in North America. Whereas dangerous commotions and insurrections have been fomented and raised in the town of Boston in the province of Massachusetts Bay in New England by divers ill-affected persons, to the subversion of His Majesty's government and to the utter destruction of the public peace and good order of the said town, in which commotions and insurrections certain valuable cargoes of tea, being the property of the East India Company, and on board certain vessels lying within the bay or harbor of Boston, were seized and destroyed. And whereas in the present condition of the said town and harbor, the commerce of His Majesty's subjects cannot be safely carried on there, nor the customs payable to His Majesty's duly collected, and it is therefore expedient that the officers of His Majesty's customs should be forthwith removed from the said town. Be it enacted that from and after June 1st, 1774, it shall not be lawful for any person or persons whatsoever to lade, put, or cause to procure, to be laden or put off or from any quarry, wharf, or other place within the said town of Boston, or in or upon any part of the shore of the bay, commonly called the harbor of Boston, between a certain headland or point called Nahant Point, on the eastern side of the entrance into the said bay, and a certain other headland or point called Alterton Point, on the western side of the entrance into the said bay, or in or upon any island, creek, landing place, bank, or other place within the said bay or headlands, into any ships, vessels, lighter, boat, or bottom, any goods, wares, or merchandise whatsoever to be transported or carried into any other country, province, or place whatsoever, or into any other part of the said province of the Massachusetts Bay in New England, or to take up, discharge, or lay on land within the said town, or in or upon any of the places aforesaid, out of any boat, any goods, wares, or merchandise whatsoever to be brought from any other country, province, or place to any other part of the said province of the Massachusetts Bay in New England, upon pain of the forfeiture of the said goods, merchandise of the said boat, and of the guns, ammunition, tackle, furniture, and stores in or belonging to the same. And if any such goods shall, within the said town, or any of the places aforesaid, be laden or taken in from the shore into any barge, to be carried on board any ship or vessel outward bound to any other country or province, or to be laden into such barge from or out of any ship or vessel coming in from any other country, such barge shall be forfeited and lost. 10. Provided also, and it is hereby declared and enacted, that nothing herein contained shall extend or be construed to enable His Majesty to appoint such port, harbor, creeks, quays, wharfs, places, or officers in the said town of Boston, or in the said bay or islands, until it shall sufficiently appear to His Majesty that the full satisfaction has been made by or on behalf of the inhabitants of the said town of Boston to the United Company of Merchants of England, trading to the West Indies, for the damage sustained by the said companies by the destruction of their goods sent to the said town of Boston on board certain ships or vessels as aforesaid, and until it shall be certified to His Majesty in council by the governor or lieutenant governor of the said province that reasonable satisfaction hath been made to the officers of His Majesty's revenue and others who suffered by the riots and insurrections above mentioned in the months of November and December in the year 1773, and in the month of January in the year 1774. Second, Massachusetts Governing Act, May 20th, 1774. On March 28th, Lord North, insisting that he wished to take the executive power from the hands of the Democratic part of the government, introduced an act for the better regulating the government of the province of Massachusetts Bay, which would effectually purge the Constitution of all its crudities. The bill passed by large majorities, but 11 lords entered a protest against it. Massachusetts largely nullified the administration of the new act. An act for better regulating the government of the province of the Massachusetts Bay in New England. As whereas the method of electing such councillors or assistants to be vested with the several powers, authorities, and privileges therein mentioned, in which the appointment of the respective governors had been vested in the general courts or assemblies of the said colonies, hath by repeated experience been found to be extremely ill adapted to the plan of the government established in the province of the Massachusetts Bay, and hath for some time past been such as had the most manifest tendency to obstruct and in great measure defeat the execution of the laws, to weaken the attachments of His Majesty's well-disposed subjects in the said province to His Majesty's government, and to encourage the ill-disposed among them to proceed even to acts of direct resistance to and defiance of His Majesty's authority. And it hath accordingly happened that an open resistance to the execution of the laws hath actually taken place in the town of Boston and the neighborhood thereof, within the said province. And whereas it is under these circumstances become absolutely necessary that the said method of annually electing the councillors or assistants of the said province should no longer be suffered to continue, but that the appointment of the said councillors or assistants should henceforth be put upon the like footing as in established in such other of His Majesty's colonies or plantations in America, the governors whereof are appointed by His Majesty's commission under the great seal of Great Britain. Be it therefore enacted, that from and after August 1st, 1774, so much of the Charter of 1691, which relates to the time and manner of electing the assistants or councillors for the said province, be revoked, and that the offices of all councillors and assistants elected and appointed in pursuance thereof shall from henceforth cease and determined, and that from and after the said August 1st, 1774, the council or court of assistants of the said province for the time being shall be composed of such of the inhabitants or proprietors of land within the same as shall be therefore nominated and appointed by His Majesty, provided that the number of the said assistants or councillors shall not at any one time exceed 36, nor be less than 12. 2. And it is hereby further enacted, that the said assistants or councillors so to be appointed as aforesaid shall hold their offices respectively for and during the pleasure of His Majesty. 3. And be it further enacted, that from and after July 1st, 1774, it shall and may be lawful for His Majesty's Governor, for the time being of the said province, or in his absence from the Lieutenant Governor, to nominate and appoint under the seal of the province from time to time, and also to remove without the consent of the council of all judges of the inferior courts of common pleas, commissioners of order and teminer, the Attorney General, provosts, marshals, justice of the peace, and other officers to the council or courts of justice belonging. 6. And be it further enacted, that upon every vacancy of the offices of Chief Justice and judges of the Superior Court of the said province, from and after July 1st, 1774, the Governor, for the time being, or in his absence, the Lieutenant Governor, without the consent of the council, shall have full power and authority to nominate and appoint the persons to succeed to the said offices, who shall hold their commissions during the pleasure of His Majesty. 7. And whereas by several acts of the General Court, the freeholders and inhabitants of the several townships, districts, and precincts, qualified as in therein expressed, are authorized to assemble together annually, or occasionally upon notice given in such manner as the said acts direct, for the choice of selectmen, constables, and other officers, and for the making and agreeing upon such necessary rules, orders, and bylaws for the directing, managing, and ordering the prudential affairs of such townships, districts, and precincts, and for other purposes. And whereas a great abuse has been made of the power of calling such meetings, and the inhabitants have, contrary to the design of their institutions, been misled to treat upon matters of the most general concern, and to pass many dangerous and unwarrantable resolves, for remedy whereof be it enacted, that from and after August 1st, 1774, no meeting shall be called by the selectmen, or at the request of any number of freeholders of any town, district, or precinct, without the leave of the governor, or in his absence of the lieutenant governor, in writing expressing the special business of the said meeting, except the annual meeting in the months of March or May, for the choice of selectmen, constables, and other officers, or except for the choice of persons to fill up the offices aforesaid, on the death or removal of any of the persons first elected to such offices, and also except any meeting for the election of a representative or representatives in the general court, and that no other matter shall be treated of at such meetings. 3. Administration of Justice Act, May 20th, 1774. This act was designed to provide for a more impartial administration of justice by transferring certain trials to other provinces or to Great Britain. It was directed not only towards the maintenance of order, but to the more efficient administration of the custom laws. An act for the impartial administration of justice in the cases of persons questioned for any acts done by them in the execution of the law, or for the suppression of riots and tumults in the province of the Massachusetts Bay in New England. Whereas in His Majesty's province of Massachusetts Bay in New England, an attempt hath lately been made to throw off the authority of the Parliament of Great Britain over the said province, and an actual and avowed resistance by open force to the execution of certain acts of Parliament hath been suffered to take place uncontrolled and unpunished. And whereas in the present disordered state of the said province, it is of the utmost importance to the reestablishment of lawful authority throughout the same, that neither the magistrates acting in support of the laws, nor any of His Majesty's subjects aiding and assisting them therein, or in the suppression of riots and tumults, should be discouraged from the proper discharge of their duty, by an apprehension that in case of their being questioned for any acts done therein, they may be liable to be brought to trial for the same before persons who do not acknowledge validity of the laws in the execution thereof, or the authority of the magistrates in support of whom such acts have been done, in order, therefore, to remove every such discouragement from the minds of His Majesty's subjects, and to induce them, upon all proper occasions, to exert themselves in support of the public peace of the province, and of the authority of the King and Parliament of Great Britain over the same. Be it enacted, that in any inquisition or indictment shall be found, or if any appeal shall be sued or preferred against any person for murder or other capital offense in the province of the Massachusetts Bay, and it shall appear by information given upon oath to the governor of the said province that the fact was committed by the person against whom such inquisition or indictment shall be found, or against whom such appeal shall be sued or preferred, as aforesaid, either in the execution of his duty as a magistrate for the suppression of riots, or in the support of the laws of revenue, or in the acting in his duty as an officer of revenue, or in acting under the direction and order of any magistrate for the suppression of riots, or for the carrying into effect the laws of revenue, or in aiding and assisting in any of the cases aforesaid. And if it shall also appear to the satisfaction of the said governor, that an indifferent trial cannot be had within the said province, in that case it shall and may be lawful for the governor to direct, with the advice of the consent of the council, that the inquisition, indictment, or appeal shall be tried in some other of the Majesty's colonies, or in Great Britain, and for that purpose to order the person against whom such inquisition or indictment shall be found to be sent under sufficient custody to the place appointed for his trial, or to admit such person to bail, taking a recognizance from such person with sufficient sureties in such sums of money as the said governor shall deem reasonable for the personal appearance of such person, if the trial shall be appointed to be had in any other colony before the governor of such colony, and if the trial shall be appointed to be had in Great Britain, then before his Majesty's Court of King Bench at a time to be mentioned in such recognizes, and the governor or court of King's Bench, where the trial is appointed to be had in Great Britain, upon the appearance of such person, according to such recognizance, or in custody, shall either commit such person or admit him to bail until such trial. 2. And to prevent a failure of justice from the want of evidence on the trial of any such inquisition, indictment, or appeal, be it further enacted, that the governor is hereby authorized and required to bind in recognizance to his Majesty all such witnesses as the prosecutor or person against whom such inquisition or indictment shall be found, or appeal sued or preferred, shall desire to attend the trial of the said inquisition, for their personal appearance at the time and place of such trial, to give evidence, and the said governor shall thereupon appoint a reasonable sum to be allowed for the expenses of every such witness. 6. Persons brought before justices, etc., accused of any capital crime in the execution of their duty, to be admitted to bail. 8. And it be further enacted that this act shall be and continue in force for and during the term of 3 years. 4. The Quebec Act, June 22nd, 1774. The Quebec Act was not, properly speaking, one of the coercive acts. It was not designed with reference to the conditions in Massachusetts or the other seaboard colonies. Nevertheless, Americans regarded its provisions for religious toleration to Catholics and for the extension of the territory of Quebec westward as intolerable. As a matter of fact, the Quebec Act was one of the most enlightened pieces of colonial administration in the history of European colonial expansion. An act for making effectual provision for the government of the province of Quebec in North America. May it therefore please your most excellent Majesty that it may be enacted, defined boundaries of the proclamation of 1763, extended to include territory west to the Mississippi, north to the frontiers of the Hudson Bay Territory, and the islands in the mouth of the St. Lawrence. And whereas the provisions made by the said proclamation in respect to the civil government of the said province of Quebec, and the powers and authorities given to the governor and other civil officers of the said province by the grants and commissions issued in consequence thereof have been found upon experience to be inapplicable to the state and circumstances of the said province, the inhabitants whereof amounted at the conquest to the above 65,000 persons professing the religion of the Church of Rome. It is hereby declared that His Majesty's subjects professing the religion of the Church of Rome and in the said province of Quebec may have, hold, and enjoy the free exercise of the religion of the Church of Rome, subject to the King's supremacy, declared and established by an act made in the first year of the reign of Queen Elizabeth over all the dominions and countries which then did or thereafter should belong to the imperial crown of his realm, and that the clergy of the said church may hold, receive, and enjoy their accustomed dues and rights with respect to such persons only as shall profess the said religion. provided, nevertheless, that it shall be lawful for his majesty, his heirs, or successors to make such provisions out of the rest of the said accustomed dues and rights for the encouragement of the Protestant religion, and for the maintenance and support of a Protestant clergy within the said province, as he or they shall from time to time think necessary or expedient. And be it further enacted by the authority aforesaid, that all his Majesty's Canadian subjects within the province of Quebec, the religious orders and communities only excepted, may also hold and enjoy their property and possessions, together with all customs and usages relative thereunto, and all other civil rights, in as large and ample and beneficial manner, as if the said proclamation, commissions, ordinances, and other acts and instruments had not been made, and as many consist with their allegiance to his Majesty's and subjection to the Crown and Parliament of Great Britain, and that in all matters of controversy relative to property and civil rights, resorts shall be had to the laws of Canada, as the roll of the decision of the same, in all causes that shall hereafter be instituted in any of the courts of justice, to be appointed within and for the said province of his Majesty, his heirs and successors, shall, within respect to such property and rights, be determined agreeably to the said laws and customs of Canada. And whereas the certainty and lenity of the criminal law of England, and the benefits and advantages resulting from the use of it, have been sensibly felt by the inhabitants from an experience of more than 9 years, during which it has been uniformly administered. Be it therefore further enacted by the authority aforesaid, that the same shall continue to be administered, and shall be observed as law in the province of Quebec, as well in the description and quality of the offense as in the method of prosecution and trial, and the punishment and forfeitures thereby inflicted, to the exclusion of every other rule of criminal law or mode of proceeding thereon, which did or might prevail in the said province before the year of our Lord 1764, anything in his act to the contrary thereof in any respect notwithstanding. And whereas it may be necessary to ordain many regulations for the future welfare and good government of the province of Quebec, the occasions of which cannot now be foreseen, nor without much delay and inconvenience be provided for, without entrusting that authority for a certain time, and upon proper restrictions to persons resident there. And where it is at present inexpedient to call an assembly, be it therefore enacted by the authority aforesaid, that it shall and may be lawful for his Majesty, and with the advice of the Privy Council, to constitute and appoint a council for the affairs of the province of Quebec, to consist of such persons resident there, not exceeding 23, nor less than 17, as his Majesty shall be pleased to appoint, which council, so appointed and nominated, or the major part thereof, shall have power and authority to make ordinances for the peace, welfare, and good government of the said province, within the consent of his Majesty's governor, or in his absence of the lieutenant governor or commander-in-chief for the time being. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.